back to Mr. Frackman. He obviously got this point a long time ago, probably way before I even understood it was an issue. And he presented his case to the inspector, the planning inspector, and indeed he was talking in terms of some of the evidence that he had discovered from fracking in the US, and he'd obviously done a lot of research there. And you know, they've got a huge amount of experience of the impact of fracking in the US. I mean, the reason why the fracking industry here is promoted is because of the success, in inverted commas, of it in the US. I mean, in terms of a money-making exercise for the companies, anyway. But the obvious difference between the US and here is the size of the US, and in comparison to the UK, you know, fracking in areas which are close to local communities in the UK is you might think just obviously more likely to have a greater impact on human health and other matters of planning importance. Anyway, Mr. Frackman presented his case. The inspector recorded it accurately, but rejected his arguments. And his arguments were very much along the lines of fracking is harmful, it's unsafe, it's not properly regulated, and it will cause contamination to water supply. It will give rise to additional greenhouse gas emissions, which we simply don't need and cannot cater for anymore in our environment. And also the point that if we don't really know quite what the impact of fracking might be, quite what harm there might be arising from this operation that Quadrilla wants to undertake, then there is something called the precautionary principle, which requires us to take the safer route, which is, in this instance, he said, to reject the application. Anyway, as I said, the inspector faithfully recorded his argument, but concluded that, as she was required to do in accordance with national planning policy, it's in a document called the National Planning Policy Framework, she concluded that as it were, the regulatory regime was sufficiently robust to ensure that any safety concerns would be properly catered for, would be properly addressed. There would be sufficient monitoring, there would be safety checks and so forth. I mean, I think anybody who's had a look at that regulatory system knows, firstly, that it's dependent on funding and manpower or womanpower, and there simply isn't enough. If you're going to have a fracking industry at scale, you know, with what, 1,000, 10,000 wells, I can't remember what the figure was, but you know, at scale, fracking will have many, many hundreds, maybe thousands of wells up and down the country. We don't have the resources, the investment in the regulatory industry to ensure that those wells will be inspected. Indeed, most of the regulatory system appears to be focused on the industry self-reporting. Yeah, so it really is leaving regulation to companies that are interested very much in profit margins, and that can't be right for those of us in this room or elsewhere, the community members who are reliant on a safe system. So all those arguments that he put forward were rejected. The Secretary of State agreed with the recommendation, granted Quadrilla planning permission in I think in respect of one or two of the sites in and around a place called Preston New Road. There was concern about one particular well because of highway safety issues and the impact of traffic, because obviously there's a lot of movement, these tankers coming in and out with the slick water that was being pumped into the fracking wells and the like, were causing a lot of concern. And ultimately, in fact, that particular application in respect of that well was rejected. There was, as it were, an adjournment for further consideration of the matter, and ultimately it was rejected. So there was a win there in that regard. But Mr. Frackman wasn't happy with the decision, nor were the Preston New Road Action Group, and they, the two, as it were, concerned parties, Mr. Frackman and the Action Group, decided to launch proceedings to challenge the grant of planning permission. And you can do that by taking a case to the planning court, which sits in it's part of it. It's a branch of the High Court, and it sits usually in London, but sometimes in Manchester, Birmingham, and Cardiff. This case went to actually a judge sitting in Manchester, Mr. Justice Dove, a very well experienced planner. As a barrister, and then a QC, and then as a judge. And the challenge brought by Preston New Road Action Group was based upon the Secretary of State's consideration of things like impact on highways and regular planning kind of considerations, which are important, obviously very important. Light pollution, noise pollution, all sorts of other obvious, as it were, impacts of the operation. Mr. Frackman went out on a bit of a limb at the time, but you may now think, well, why wouldn't he? And said through us that exploratory fracking was obviously going to lead, if they were successful and they got sufficient gas out of the ground when carrying out this exploratory drilling, was obviously going to lead to an application for full permission for the fracking operation to continue for its life time, which could be up to 10, 15 years. And the question is, has there been any assessment of what the greenhouse gas emissions arising from the fracking operation after the exploratory operation is completed, so the full permission, as it were? Has there been any real assessment of those greenhouse gas emissions? Because what's the point of granting permission for exploratory drilling if you haven't assessed what the greenhouse gas emissions impact will be from the fracking thereafter? The court, Mr. Justice Dove, said, well, look, that argument wasn't really run at the planning inquiry, and it hadn't been. It was something dreamt up by us, I must admit, when we looked at the papers and thought, what's the point in granting permission for the exploratory phase when you're going to be, as a consequence, allowing Quadrilla to emit huge quantities of greenhouse gas, CO2 and methane, as Lorraine was saying, fugitive emissions which occur regularly at these sites. Quadrilla's argument, and again they were represented, as was the Secretary of State in the challenge before Mr. Justice Dove, was, well, the greenhouse gas that's coming, the shale gas that we are going to frack at the exploratory phase, that will all be pumped into the national grid, and it will replace liquid gas, which we've had to import. Liquefied gas, which we've had to import, and there's a as it were a lower greenhouse gas footprint arising from shale gas emissions extracted in the UK. Now I'm not sure that is. We found it difficult to really find much to challenge that point on, but I think the MOBS report. I think there's been some more recent evidence which would have helped us then. But the point was that. If you look at the government's own reports on gas security, the gas, it seems that we've got a secure supply of gas until the point of time when there's no need for gas. And the question is, how quick do we need to move from gas anyway to renewables? And it seems that the window or for us continuing to use any type of gas is closing, And what we were saying is this shale gas is not, as the government was suggesting, a bridging fuel or a transition fuel, a fuel which can get us from coal to renewables. Anyway, those were the points we ran at the before Mr. Justice Dove. He rejected those points. He also rejected an argument which we put forward, which was on the basis that the planning policy, which said that the regulatory scheme was robust and decision makers should consider it so, that policy itself was in breach of that precautionary principle that I talked about earlier on. We were saying, look, you can't just have a policy that gives carte blanche to developers and decision makers on the basis that there is a regulatory scheme. If you don't look at the regulatory scheme and appreciate that actually it's not really all it's cracked up to be.